Hi, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about traffic signs. Cases that should have gone to the Supreme Court of Canada, but didn't. Interestingly, in Canadian law, there are regulations about where traffic signs have to be posted on the roadway, the information that has to be contained on those signs, and how visible those signs have to be to drivers. Seems to make sense. But there's also in Canadian law a presumption that if there's a sign in place, it meets all of those requirements, even if it doesn't. And the onus is on the person arguing the sign isn't proper to prove that it wasn't proper. Pierre Waters found himself facing a traffic ticket. He was alleged to be going 97 kilometers an hour in a 50 zone on a road in Quebec. And at trial, he argued that this sign that was posted on the roadway saying that the speed limit was 50 kilometers an hour did not comply with the regulations for the mounting of signs. The court dismissed his application for relief on the basis of the fact that there was this presumption of regularity, and he sought leave to appeal to the Supreme Court of Canada, which was dismissed. The interesting issue that Mr. Waters' case raises is this question of when can you overcome the presumption of regularity, and what evidence is required. Mr. Waters wanted clarification from the Supreme Court of Canada of in what circumstances does the presumption of regularity apply, and what the Crown has to establish before that presumption takes place. Unfortunately, the Supreme Court of Canada denied leave. Really, it's not surprising, because a traffic ticket is not the type of case that's of national importance, but the case does raise more significant issues surrounding the application of other presumptions of regularity in other administrative and regulatory contexts. And the Supreme Court of Canada had an opportunity here to confirm that in other contexts and to make the application of these presumptions more clear for people facing tribunals or traffic courts, which are largely do-it-yourself processes. They missed this opportunity, and it's going to take another day for the Supreme Court of Canada to really clarify the state of the law when it comes to presumptions of regularity, not just with signs, but generally, and when those can apply. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to this week's episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos, and please like, subscribe, and share with your friends.